Good evening, Chief Justice, and may it please the Court.
It does.
My name is Thomas Fowler, and I represent the respondent, the United States, acting on behalf of its subordinate unit, the Environmental Protection Agency. Excuse me. This Court has jurisdiction over the appeal pursuant to 28 U.S.C. 1297, and the standard for review and a choice of law appeal is de novo. The issue presented to the Court this evening is whether to apply state or federal common law and successor liability claims arising under CERCLA. It is the respondent's contention that this Court should uphold the District Court of Clarkson's application of federal common law and successor liability claims arising under CERCLA, and should do so for the following two reasons. One, pursuant to U.S. v. Kimmel Foods, the very nature of CERCLA requires the application of the federal common law. Two, and the most dispositive reason, the application of West Dakota state law would severely frustrate the specific purposes as CERCLA was enacted to achieve.
Counsel, but isn't the idea of federalism pretty important here, that a state can deal with its state and its businesses the way it wants to?
Yes, it is very important in federalism. Our nation was founded upon federalism. But
you're wanting us to...
Well, when it comes to the environment and the protection of the nation as a whole, sometimes state rights have to take a second chair to federal interests. And when it comes to pollution, something that happens in California could affect Oregon, something that happens in Missouri could affect Iowa. So if we were to allow a state to interpret CERCLA in such a way that would allow for more lax laws on pollution, that pollution there would not only affect the state that passed those laws, it could also affect their neighboring states, and therefore it's a federal interest, and the federal interest should
Well, our issue here
supersede.
today isn't about the pollution. The states and the businesses are still subject to the same pollution requirements. This is just about the EPA getting its money back, isn't it?
Ultimately, yes, the EPA wants to get its money back, but the congressional record shows, and it's Representative Florio who really talked about it, and you mentioned it in the appellant's brief, kind of the race to the bottom idea, where a state might enact laws that would bring in business and there would be pollution, and they would be thinking that, well, since this state doesn't have a de facto merger test, I can just either wait for the government to come after me, or if they do come after me, I'll give my assets to my daughter and hope that it passes the easier standards of state law.
Is that the factual situation here, counsel?
I should have asked if you wanted to hear the facts, and if you would like, I could run a brief.
We don't need a full recitation. I'm just asking if that situation you just stated.
Yeah, it would appear that
it would
appear that yes, those are the facts.
I have a question for you, and it's a hypothetical, so let me set it up a little bit. In this case, the state law makes it harder for the EPA to recruit money from the appellant because of the one missing doctrine, correct?
Correct.
Okay, what if, hypothetically, the state of East Dakota had a state law in place that made it easier for the EPA to recoup money from the appellant? For instance, East Dakota's law might state if any corporation has one board member who is the same as a previous corporation, they can be held liable as a successor under environmental cleanup laws. Would you still be arguing that uniformity is so important, or would you try to use East Dakota's state-specific law?
That's the extreme example, and CERCLA is a very encompassing statute, and it pulls in a lot of people. And it would maybe hurt East Dakota that businesses would want to go to West Dakota to have their more lax laws.
Right, but which statute would you rather use?
You, as the government.
As a government, obviously I would want to use a broader statute, I think, so I would be able to get the most money and remediate the sites and then get them back on the market.
So the uniformity amongst all states that a federal common law gives us, that's not really as important, is it?
No, I do believe that a uniformity is important because if we go down to the third prong of the Kimmel test, where if federal law is going to displace state law, you have to be careful of the pre-existing commercial relationships that are predicated on that state law. And the idea of not knowing exactly which law is going to be applied could stifle business transactions, and it just wouldn't be good policy.
But even if we accept your opponent's argument, corporations are going to know what law applies. It will be the law of that state.
Yes and no. There's circuit splits that have been going on since the enactment of CERCLA. And Best Foods, which completely ignores Kimmel and doesn't mention the framework at all. Best Foods, almost in a way, goes for the application of a federal common law. And I say that because what they applied was not an individual state law. It was the hornbook concepts of what successor liability should be. It didn't pick an individual state law. It picked the federal common law to apply. But
Counsel, but isn't your proposal would make it possible that a successor corporation would be considered a successor corporation for CERCLA purposes, but would not be considered a successor corporation under a separate state law situation?
yes, that is true.
And that you're okay with that in